Early lease termination, whether the landlord or tenant wants out, is one of the more legally sensitive situations in rental property management. When the tenant wants to terminate early, a fixed-term lease is a binding contract. The tenant owes rent for the full term unless the lease has an early termination clause, state law provides an exception, or you agree to release them. Most states require landlords to make a reasonable effort to re-rent the unit after a tenant breaks a lease. This is called the duty to mitigate. You can charge the tenant the rent lost during vacancy plus releasing costs, but you can't just let the unit sit and bill them for the full remaining term. State law exceptions that allow tenants to break a lease without penalty include active military deployment under the Service Members Civil Relief Act, domestic violence situations with proper documentation, landlord failure to maintain habitability, and in some states, job relocation or death. When the landlord wants to terminate early, you generally cannot end a fixed-term lease without cause before it expires unless the lease includes a specific early termination clause. Valid grounds are lease violation, non-payment, illegal activity, or legitimate no-fault reasons like owner move-in or demolition, which may require relocation assistance. Never accept a tenant's verbal promise to leave. Get any early termination agreement in writing, specify the move-out date, the return of keys, the security deposit process, and what rent, if any, is still owed. Tenant screening backgroundcheck.com. Place tenants more likely to stay and honor their commitments.